This video covers modifying child custody in Louisiana. If you're watching this, you may be considering changing an existing child custody order. We'll walk you through the process and answer some common questions you might have. Before you start the process, it's important to know what kind of custody order you have. If your order was decided by a judge after a trial, it's a considered judgment. If your order was agreed upon by both parents, it's a consent judgment, which may be easier to modify. It's also important to understand the requirements for modifying a child custody order. If you have a consent judgment and you want to modify the custody order, there are two things you need to show to the court. First, you must demonstrate that there has been a material change in circumstances since the existing custody order. This means that something significant has happened that affects the well-being of the children or the ability of the parents to fulfill their parental responsibilities. This could include a change in the child's living situation, a parent's relocation, or a significant change in the child's needs. Second, you need to prove that the proposed change in custody is in the best interest of the child. This means that the modification you are requesting will benefit the child and promote their overall well-being. To support your request for modifying a consent judgment, gather any evidence that demonstrates the material change in circumstances and how the proposed change in custody will be in the best interest of the child. This evidence could include documentation, witness statements, or any other relevant information. Before you file a formal request, you may consider trying to negotiate with the other parent through mediation or informal discussions. Once you've determined that you meet the requirements for modifying your custody order, you'll need to fill out the appropriate form. In Louisiana, this is called the Rule to Modify Custody. It's important to provide accurate and detailed information about the existing order, the proposed changes, and the reasons for the modifications. After completing the form, make at least 2 copies. These copies will be important for your records and for serving the other party involved. It's always a good idea to keep a copy of all the documents related to your case. Now it's time to file the form with the appropriate clerk of court. Bring the original form and the copies you made. Ask the clerk to file all the contents included with the form and request a date stamp on the copies you brought. Remember, there may be filing fees associated with submitting the form. If you're unable to pay the fees up front, you may qualify for a fee waiver application. Inquire with the clerk about the necessary steps to apply for a fee waiver. After you've filed the form with the court, you'll need to serve the other parent with a copy of the papers. This lets them know about the upcoming court date and gives them a chance to respond to your request. On the day of the hearing, you'll need to attend court and explain your request to the judge. Be sure to bring all your evidence and any witnesses you wish to testify. After both parties have had a chance to speak, the judge will make a decision. The judge will carefully consider the best interests of the child before making a decision. It may take several court dates for the matter to be resolved. Remember, modifying a custody order can be a complex process, but it's important to do what's in the best interests of the child. It's important to consult with an attorney or seek legal advice to navigate this process if you have any questions or need help.